On multiple occasions, the defendant made the statement, I shouldn't effing be here.
The fact that she tried to commit suicide, the fact that she was despondent over what she had done is huge.
I just don't find in this court's opinion that her expressions of remorse today particularly sincere.
I did not feel safe leaving her by herself.
Is she a threat? No, she'll never work in a daycare center ever again in her life.
Welcome back to the court bench. Today, we're looking into the sentencing phase of a harrowing case from Tennessee. The defendant, Sarah Fuson, was convicted of both aggravated child abuse and child abuse, facing the mandatory minimum of 15 years. This hearing is where the court decides her fate, weighing the impact of her actions against arguments for leniency. This case garnered significant attention due to the fact that Fuson is the daughter of local Sheriff John Fuson, which led to the trial needing to be moved out of Montgomery County, Tennessee, to Dixon. We'll begin by hearing from Macy Hyde, the devastated mother of her 13-month-old child who endured severe abuse at a daycare under Sarah Fuson's care.
My name is Macy Hyde, and I am the mother of Olivia, the child who has been deeply harmed in this case. When I first saw the bruises on Olivia's little arms, I felt confusion, fear, and indescribable pain. I had trusted Sarah with the most precious thing in my life, my daughter, and that trust was shattered. Since the abuse, our lives have been consumed by emotional turmoil, fear, and uncertainty. Olivia, though too young to fully understand what has happened, continues to suffer the effects. For months after the incident, she woke up screaming in the night. Putting her down at naps and bedtime became an emotionally charged ordeal. Even a year after the abuse, she still exhibited signs of trauma. We had to seek play therapy because she refused to let us touch the backs of her arms. A simple touch in the wrong place could trigger a meltdown, with Olivia begging us not to touch her that way, as if she was reliving the horrors. As a mother, the emotional turmoil has been unbearable. Every day, I live with the constant anxiety that my children may be hurt again. I regret deeply that I took Olivia back to Sarah the day after the abuse. The guilt that haunts me for that decision weighs heavily on my heart, and I still to this day struggle to forgive myself. After watching the trial videos, my husband and I experienced nightmares. We both sought therapy to cope with the trauma, including EMDR, to help erase the haunting memories. This summer, I struggled to send our son to daycare after we moved. The anxiety becomes so overwhelming for me that I almost pulled him out after just 3 days of being there, fearing the worst from what had happened to Olivia. Thankfully, Olivia is now in a school environment with teachers whom I trust, but the fear remains. The trust we once had in the world around us is shattered. Sending my children to school or leaving them in the care of others now feels like a risk that I cannot fully bear. The ripple effects of this trauma has permeated every part of our lives. No parent should have to question whether their child will carry lasting pain from something that they never should have had to endure. This trauma has fundamentally altered me, both as a mother and as an individual, and I am no longer the person I was before the abuse. I am forever changed. Your Honor, I ask the court to remember that behind this case is a real child, a baby who was frightened, abused, and betrayed. I ask the court to fully understand the deep, lasting harm that this has caused to Olivia and our family.
Thank you.
This was an emotional and powerful victim impact statement from the victim's mother, Macy Hyde. The purpose of a victim impact statement in a case like this is to inform the court of the financial, emotional, psychological, and physical effects of the crime on the victim. These statements don't change the defendant's guilt, which has already been established by a jury, but they absolutely influence the judge's sentencing decision, particularly when considering the severity of the harm and whether to impose a higher sentence within the statutory range. Next, we'll hear from Sarah Fuson's mother as she attempts to curry sympathy and defend her daughter's character.
When Sarah was born, she was the biggest gift in our life. She was actively involved in so many activities and so many things. We were actively involved in our church. And one of the greatest blessings was she was baptized at age 7. And that gives me lots of comfort.
If you would describe for the judge the impact that this prosecution and trial has had on Sarah.
The impact it has had on Sarah is great. She attempted suicide. We committed her to a mental hospital for a couple of weeks. She came home on lots of mind-altering medications. Trying to get a new job was very embarrassing, to say the least. She would attempt one after another with the charges on her record. During this period, I made sure Sarah was with me or someone at all times. I did not feel safe leaving her by herself.
Is there anything that you would like to say to the Hyde family?
Yes, I would. I am so sorry for all of your pain and all of the trauma and all of the mistrust in society that this has caused you. We do not, as a family, condone what Sarah did that day. We don't, but we do love our daughter. And just as you see, anything your children do in life, you try your best to raise them and support them and get them through the hard things in life. Sarah is not a throwaway person. She is kind. She is generous. She is loving. We need her. We depend on her. And we will have a big hole at our table and in our hearts until she is returned home to us.
Thank you. Those are my questions.
Thank you, ma'am. You may step down. Defense have any other proof? All right, an allocution statement will be allowed, so she'll need to come to the podium or actually come to the witness stand.
This was an attempt to persuade the judge to consider a lighter sentence, focusing on rehabilitative aspects and the defendant's potential for good, which falls under general mitigating factors recognized in sentencing guidelines. However, it's a fine line to walk as the gravity of the crime often overshadows personal pleas. We'll now hear from Sarah Fuson herself in her allocution, the right of a defendant to make a statement to the court before sentencing.
You don't have to be sworn. This is an unsworn allocution, which you're allowed to make a statement without having to be placed under oath. So.
Good morning. Go forward with your statement.
I want to start by apologizing to Ms. James, the probation officer, about my comments about the case. I never intended to hurt Olivia. I didn't realize I was being rough with Olivia in the moment. I recognize that I was rough with her and regret my conduct. To Olivia and her parents, I am so very sorry that this happened and what this has put your family through and the trauma that Olivia had to go through. If I could go back and make this right, I would have been calm and gentle as usually I was and not rough. I love children and animals, and it is not in my nature to be rough. I hope someday that Olivia and her family can forgive me and we can move past this. I want to thank my parents and my family for supporting me and standing by me through this very difficult process.
While this allocution was not testimony under oath, presenting a sincere expression of remorse can sometimes influence a judge's decision regarding leniency. Later, we'll hear what the judge thought about her sincerity, particularly in regards to her earlier statements to the pre-sentence report investigator. Remember, the judge must assess not just her words, but the credibility and consistency of the remorse, which is crucial in determining if a defendant has truly accepted responsibility. Next, we'll hear the prosecutor argue for the application of aggravating factors, which are circumstances that increase the culpability of the defendant and can justify a harsher sentence above the minimum.
13-month-old victim that did not have the resist in any way. She didn't have the ability to tell someone and ask for help, nor did she have the ability to testify as to what occurred at a later date. Enhancement factor of trust. Ms. Fuson was in a position of trust. No greater trust than caring for that of someone else's children. Enhancement factor on the grounds of a pre-kindergarten while children were present. It just says while they were present, that's what occurred in this case. We think all three enhancement factors apply, and we'd ask that Your Honor include those in your consideration.
After hearing these aggravating factors, we'll now see the defense attorney present mitigating factors, which are circumstances that may warrant a lighter sentence. With Fusen's lack of prior criminal record, the isolated nature of the incident, her despondency, and even an attempt to take her own life, as we'll hear, demonstrate remorse and a character generally inconsistent with prolonged abuse. They contend that these factors should lead the judge to impose the minimum 15-year sentence rather than an enhanced one.
15 to 25 years. Under recent amendments to the law that apply in this case, it is 100%. There's no parole. There are no credits. State sentencing memorandum focuses on the aggravating factors, which I'll address in a moment. But there are other important parts to the sentencing statute. So let's talk about the vulnerability of the victim. It is an element of the crime. They had to prove severe injury. They had to prove that the child was under 8. And if it does apply, it is so close to an element of defense, it runs the risk of double counting. So I suggest that factor's off the table. Position of trust. She was not licensed. She was in a position of care of these children. Mitigation, which we have to consider. The mitigating factors are abundant. My client had never been arrested in her life. No prior record at all. This event occurred on one occasion, and not like the many child abuse cases that Your Honor sees where it goes on for weeks and months and years. It's an isolated event. So those are mitigating factors there. The fact that she tried to commit suicide, the fact that she was despondent over what she had done is huge mitigation in the case and detracts from whatever abuse there exists. And so I suggest that when you consider all this mitigation involved in the case, that 15 years is the appropriate sentence. Ms. Fuson does not have any prior history. The sentencing principle says the sentence imposed should be no greater than that deserved for the offense committed. Why in the world should this woman deserve more than 15 years? Minimum sentence within the range of punishment is the sentence that should be imposed. A risk assessment. This risk assessment is low. That is a factor the court's required to consider. Is she a threat? No, she'll never work in a daycare center ever again in her life. Her risk is low. Is that a mitigating factor? Of course. This is not an issue of how tough we can be or what it looks like or making one side happy. Let's look at the person as an individual and ask what is deserved. Locking this woman up in a cage for more than 15 years, I suggest, the state suggests, their position is unconscionable, inconsistent with notions of mercy. Here, as a human being, these laws were designed to reflect a sentence for her. Sentencing guidelines are advisory, but at the end of the day, it's a very human experience. No sentence more than 15 years is deserved. It would be inconsistent with the rest of the guidelines. And I thank you, Your Honor.
Now that we've heard victim impact statements, arguments for aggravating factors from the prosecution, arguments for mitigating factors from the defense, it is now time for the judge to consider all of the information he has been given and reveal the sentence in the case against Sarah Fusen and her 2 charges of aggravated child abuse and child abuse.
Well, any court that has to impose a sentence in a case like this is required to follow the considerations and the guidelines that our state legislature has put in place to govern the sentencing in criminal cases. Sentences involving confinement should be based on the following considerations. The minimum sentence is 15 years, and the service is 100%, meaning she's not eligible at any point in time. The sentence should be no greater than that deserved for the offense committed. The first thing I'm required to do then after that is to consider the range of defendant as a criminal offender, and there's no dispute about the fact that she is a range 1 offender, which means that the range of sentence for count 1, which she was convicted of aggravated child abuse, is 15 to 25 years, and that range of sentence for count 2, which is child abuse, and that is a range of 2 to 4 years because it's a Class D felony. Then the court has to look at the mitigating and enhancing factors in order to determine whether or not the minimum sentence should apply or whether or not a greater sentence should be imposed. This court has observed this trial from the very beginning and listened to the testimony, listened to all of the medical proof that was provided. I have reviewed that video, watched the video that was provided at court, and as a result of that, the jury found that the defendant had committed the offense of aggravated child abuse. The defendant has argued from the beginning that she didn't really hurt this child in a severe way, but Dr. Lakin testified that there was both a concussion and a probable fracture of the skull, and that it did amount to severe child abuse. Now, looking then to the aggravated and mitigating factors that I'm required to consider, the first consideration is the victim of the offense was particularly vulnerable because of age or mental disability. I do not find that victim of the offense particularly vulnerable because of age or mental disability is a factor I can consider. Number 4 does not apply. Number 14, that the state says the defendant abused a position of public trust or private trust or used a professional license in a manner that significantly facilitated the commission or fulfillment of the offense. There is no greater position of trust to provide care for a minor child. I do find that this is a position of trust and that factor would factor in as an enhancement provision. Last one is that the defendant committed the offense on the grounds of the facilities of pre-kindergarten through 12 public or private institution of learning where minors are present. The offense was committed on the grounds of the facilities of a pre-kindergarten. So based on those factors, I find that both of those factors are applicable in the case. The defense has factors, and they argue that Sarah Jo Fuson's youthfulness at the time of the offense is a factor that the court should be considering. This is not a situation. She was 22 years of age, and she had attended college, had an associate's degree, had worked in the past. So I do not find that that is a factor applied because of her age. She should have known better based on her experience. And the second they've cited is she lacked a sustained intent to violate the law. And that one is basically that the offense was committed. She committed the such unusual circumstances, number 11. The defendant, although guilty of a crime, committed the offense under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the criminal conduct. Dr. Lakin observed that video, observed the child's behavior and Ms. Fuson's behavior, and at that point in time, Dr. Lakin said this child was unconscious. As a result of that, it is my opinion that there was a sustained intent to abuse this child as demonstrated from the behavior of starting with slamming the child down at the table, putting bruises on the child's arm, and then 8 times that she forced this child's head down on that. So I do not find that that factor is a mitigating factor as well. The third one is the work ethic and family contribution. The family has supported Ms. Fuson. There is proof that would sustain that as a mitigating factor. So I do find that that factor would be applicable in this case. The defendant's behavior during the course of the trial and her testimony from the stand during the trial. Ms. Fuson not only didn't accept responsibility for her actions, she minimized those actions. When the pre-sentence report was prepared, the defendant reported that she was not frustrated during the incident and was only trying to keep the child from falling out of her chair during feeding and trying to get the child to take a nap during nap time. On multiple occasions, the defendant made the statement, "I shouldn't effing be here. I didn't do anything." She also stated the victim's mother is a liar. The interview became solely focused on how this incident has affected the defendant with no concern for the child. That is the pre-sentence version of the events that Ms. Fuson gave. Now today, we saw a different side of her. I just don't find in this court's opinion that her expressions of remorse today particularly sincere. Count 1 of this indictment. The defendant should be sentenced to 20 years in the Tennessee Department of Corrections. In count 2, she should be sentenced to 4 years in the Tennessee Department of Corrections, and those sentences will run concurrently with one another. And that is the judgment of the court.
The sentence handed down by Judge David D. Wolf on December 11, 2025, means Sarah Fuson will serve a total of 20 years in the Tennessee Department of Corrections for aggravated child abuse and 4 years for child abuse. These sentences were ordered to run concurrently, meaning she will serve a 20-year term. What's more is that the judge specified that Fuson must serve 100% of her sentence with no eligibility for parole or credits, reflecting the severe nature of the crime and the judge's findings regarding her lack of genuine remorse. This outcome brings a measure of justice for the Hyde family, though as Macy Hyde expressed, the trauma will undoubtedly last a lifetime. Thank you for watching. Comment down below your thoughts on this case, and if you liked this video, please subscribe to get the latest from our channel.